And it's nice to hear your voice so active in the morning, because I know what happens during the last 10 days of Ramadan.
Oh, thank you. Thank you. Sometimes you have to, you have to be active.
Well, we do pray that Allah listens to your prayers and grants what you're asking of.
Amen.
Yeah.
We're in the last days of the Ramadan, and by the holy prescriptions, these last days contain a very significant night, the night in which the Holy Quran was revealed. A prayer that concerns with the time of the Laylatul Qadr, is called Laylatul Qadr, will be equivalent to a prayer for 1,000 nights. That translates into about 83.4 months, 83 years, 4 months. That you have worshipped your Lord. We pray that all Muslims across the world and globe are favored to meet the time and hour of Laylatul Qadr.
I like it. I don't know if did you make time to listen to the Attorney General's press conference?
Oh, I did. I mean, that was a major disaster. How could you have missed that? I'm sure even all that has listened, including members of the opposition. Yeah, I'm sure they listened.
What do you make of the revelations he made, especially in the case of Kobina Eduboing?
I was not surprised. Because we have always had an indication and a feeling that the Nana Akufo-Addo government did not manage this country very well. It appears that people were doing what they want at their various departments, agencies, and ministries, and that Nana Akufo-Addo did absolutely nothing about it. But we were shocked at the extent of the rot, of the extent of the culpability, if you want, or criminal acts perpetrated by the head of NITA. And the Attorney General also did say that, well, what they are uncovering, the Aduboahene case appears to be a tip at on the iceberg. That is, it will be small, insignificant in comparison to what they are presently uncovering. So we should brace ourselves for more.
But how significant are the details to perhaps maybe pushing a case against him? Because Attorney General seems quite confident.
They're very, very significant in the sense that, now, first of all, so we are told that the National Signals Bureau imported a spyware from an Israeli company. And we are told that the cost of the spyware was about $7 million. Now, so the question is, how was the $7 million arrived at? Who approved it? What did it go to because it's a public procurement, did it go to the Public Procurement Authority? Did they approve it? What source and method was used? So there are many questions. I'm sure that is part of the investigations that the Attorney General is doing. Then there was a settlement of the cost of the spyware, in the sense that when the amount of $7 million was agreed upon between the government of Ghana, acting through national security, and the company in Israel, amount of $7 million was transferred to the company. It's interesting to note that from the chronology of events, the amount was first transferred from the National Signals Bureau's account into a private account. It's also revealing to note that private account in which the money was transferred to bore almost a similar name with the name of the account in which the monies of National Signals Bureau are lodged. Now, was it meant to pass off that private account as an account of National National Signals Bureau to the vendors? Or why did the money have to go from the account of the National Signals Bureau to a private account before the money could be transferred? So that's a question that ought to have to be answered. Now, we are also told that when the amount finally hits the account of the private National Signals Bureau account, a lesser amount, an equivalent of 1 million, a little over 1 million, was transferred to the Israeli company. And we are not told whether subsequent transfers occurred that put the total cost of the total transfers to the Israeli company at 7 million. What we just know from the account of the Attorney General is that one bullet transfer was what was done or effectuated for the purchase of the spyware. Doesn't mean that all the other monies that the National Signal Bureau transferred into a private account were profits made on the transaction by the holder of the account. Or what happened, or if you want to put it this way, what happened to the remaining amount? Or does it also mean that the cost that the National Signal Bureau said it was buying, the price at which National Signal said it was buying the spyware did not reflect the actual cost of the equipment? So there are many questions. There are many questions that ought to be answered, and that should form part of the investigation. I mean, is there a board approval? Was there a board? The National Security Bureau have a board? Did the board say to consider the purchase of the spyware? Were they convinced that that was the amount? What due diligence did they do to come to the understanding that that was the amount at which? Because I know the Israeli company sells spyware to many other countries. So what due diligence did they do to arrive at that cost? Or was it just a matter of conspiracy to defraud the state? So there are many questions to be answered. Now, people have also spoken. So to be able to tie the evidence that is emerging from the Adubayin case to criminality, you will see that the Attorney General is trying to link the amount of money that was transferred to the Israeli company less the amount of money that was transferred from the National Signals Bureau account to properties owned by the Charles Adubahin. That should give you an indication that the Attorney General is also looking at money laundering. So he's trying to say that, well, the 39 million Ghana cedis was then funneled into certain activities to hide the money, and those activities were building the houses or purchasing properties.
Quite interesting, because when you raise that question of how was the 7 million arrived at, then you're talking about everybody that was involved in making that determination, who gave approval, among others. Is that to suggest that this investigation may go beyond even if any wrongdoing is found against Kobna Adubayin, others may also find themselves culpable?
Yes, so if all the processes were gone through, so we are assuming that they were processes, then all those people connected with those processes will have questions to answer. Because they were not just conveyor belts. They were to do some due diligence. All of them were to do some due diligence as It concerned them. So the board, they didn't need a spyware. They didn't need the equipment. What was the cost of the equipment? How were they convinced that the chief executive officer and the procurement officer of the National Signals Bureau had done their due diligence and arrived at the cost, or whether the cost was competitive, where could they get the spyware at a lesser cost, and all those things. And so those guys will have to. So we are assuming that these institutions or mechanisms or structures were there that did the work. But it could well happen that the structures were non-existent, or they were the Adubuahin and the wife were the structures, and the structures were the wife. So it could well be. But I'm saying that in the normal public service activity, there are many layers of checks and balances. So if we investigate and find that those structures did exist but failed or neglected to perform their duties, they'll be complicit in the matter.
And in discussing this matter, I wonder if you have seen the statement that was issued by Samuel Atacha.
Yeah, I've read part of it. It's a very long statement.
Yes, 4 pages. But I guess the point he's trying to make is that he feels that a press conference of such nature was not the appropriate forum. That the Attorney General should have made his case in court, not to call a press conference.
So you need to understand. I understand Atacha. I mean, I'm a lawyer too. If I were representing a client, I would definitely also raise those issues because I'm a lawyer. So you're fighting for the interests of your client. So I do understand the point he's raised about media trial. But you have to weigh that against the right of the public to know what the situation is in connection with the acts of criminality that were perpetrated against the state by appointees of the criminal government, especially when those appointees had been announced publicly as having been arrested. And you can't arrest somebody publicly and then keep everything under wraps until you go to court. The lawyers again will raise issue because arresting somebody publicly raises a prima facie case that person is a subject of interest in the criminal matter. So why do you keep it under wraps? So you see, you have to balance all these things: the right of the public to know why the person was arrested at the airport, with the right to protect the innocence of that person. And to add briefly, that in the view of the law, criminal justice system, the person who is the subject matter of a crime will have to go to court. I mean, the Attorney General will have to go to court for the court to uphold his right to innocence, but not to say that, well, because I have been arrested, I need not to have been arrested, or my case need not to be spoken of because I have a right to a presumption of innocence.
He also raises issue with what he said is an inquiry bill, that he feels that what should have been done is that the Kobna Adubuahin be taken to court, and then they can then request for bail in court.
So if the Attorney General, but this is a lawyer who understands the processes. If the Attorney General is not sending Kobna Adubuahin to court, they can go to court and an application, the relevant application, invoke the jurisdiction of the court to grant Kobna Adubuahin bail. So they know what to do. I know that Atacha knows what to do, but cannot compel the Attorney General outside the constitutional injunction, which allows the Attorney General or any arresting authority to arrest and detain a person for not more than a period of 48 hours to send that person to court for bail applications. And the Attorney General knows, I mean, you heard him yesterday, he knows that his legal limit for holding a person is to hold that person for 48 hours. And if in 48 hours he's not finished with his investigations, there are two options opened. Either he sends that person to the court to ask for the court to remand the person for investigations to continue, or he releases that person and rearrests that person again.
I see. So I guess very interesting days ahead, because Atachi also says that he's waiting to go to court and face off with Dr. Dominic Ayine, and they will see who knows the law better.
No, it's not about who knows the law. It's to defend the interests of their client. We have always been told in the law school, when we're all reading the law, that you don't supplant yourself in the shoes of the accused person. No, you are a lawyer. Is that Atachi who is in standing trial? It's Adubuahin. If the case final goes to court, it will be Adubuahin who will be standing trial. And the lawyers for Adubuahin cannot take the place of Adubuahin in the trial. So it's not a matter of who knows the law. It just, I mean, what law is he talking about? Because criminal jurisprudence and criminal law is almost like a straight jacket. That's why the law is coded. It's a coded law. So if he is charged with an offense, the facts of the case will disclose the nature of the offense. Okay, when it happened and all those things. Now, the facts will give you an indication of the type of charges that were brought against the accused person. The charges will also disclose the ingredients of the offense. Ingredients of the offense. So, for instance, if they are talking about the properties and they are saying that, well, he laundered the money. So, there will be the laundering arises from the commission of a substantive offense. So, what is the substantive offense? Even though our laws in Ghana says that you can prosecute a person if you don't get the substantive offense, or if the substantive offense was committed in another jurisdiction. But if they can get, we will know how the money laundering occurred. Okay, if they said he defrauded by false pretenses, it should be there. The ingredients of the offense will be there. If we said that he stole, it will be there. The ingredients will be there. So it's not that matter. And so the Attorney General's office, what they have to do in a criminal trial, they just show that these ingredients are there and they have been proven. To prove those ingredients. And then when they prove those ingredients, then the court will say that, well, we'll call upon the accused person to open his defense. If the ingredients have not been proven to satisfaction, the counsel for the defendants will file a motion to argue that there is no cause to answer because they have not proven the guilt of the prima facie, the guilt of the accused persons. So they have made it just I mean, like Afari, what was his name? The late Justice Afari told me when I was a very young lawyer in the Quality Grain case. For a criminal justice system, it's so straightforward that a first year, second year a practitioner can move a motion on no cause to answer. Because you just look at the ingredient, look at the evidence, does the evidence satisfy the ingredients of the offense? If in your view it doesn't, and you can demonstrate that by the evidence that has been produced and show clearly how it doesn't satisfy, which court will say that, well, the person should open his defense. So it's not a question of, so again, like I said, just as the father said, a first and second year student, a practitioner of the law can move a motion on no cause to answer. It simply means that you don't need the experience of a Methuselah in law to defend a criminal, defend a defendant in the criminal case.
I see. Well, a few things, two other things he said. One, he seems to be saying in the case of the National Service Authority, he says they have spoken to 8 people, they are singing. But the two things that attracted our attention was, one, the fact that he is making a public offer to those involved, that if you would like to come to us and perhaps reach an agreement, strike a deal, and provide the information you need, we will do that. We are open to it. But if not, we have enough to go against everybody involved. Why would the Attorney General do that?
Oh, it's part of the legal regime of this country. So when we're in Parliament, we passed the Plea Bargain Act. And the Plea Bargain Act is just informed by one condition. That we are doing what we are doing because we want to, in the name of the policy, recover the loot. It's not that we want to punish the people. We want to recover the loot. And to recover the loot, if the people say, well, we will bring back the money, that doesn't exonerate them. But that will in fact probably mitigate or lessen the sentence. You heard him say that they might receive reduced sentences. For one, a trial can be a long process and it can take a lot of time. So if they volunteer to bring back the loot, repay the loot, and invoke the provisions of the Plea Bargain Law Act to support their act, it will not exonerate them, or to repeat what I've said earlier, to drum home what the whole thing is about. It will not exonerate them from the offense, but the state would have recovered the loot.
Then there's the other thing about an MP. They didn't mention the MP's name. They said the MP was actually paid to kill the story and also defend the persons involved in public. Now, aside being shamed when his name is mentioned, can anything be brought against the MP?
So that's why you also heard him say that some of the witnesses, some of the persons who are connected with the commission of the crime, they are going to use them as prosecution witnesses. So if you say you have not committed a crime, why will you pay an MP to kill the story? And so if the MP probably is used as a prosecution witness, the evidence of the MP that he was paid to kill a story will lend further weight to the intentional crime that was committed against the state.
Is that why they avoided mentioning the MP's name, to give him the opportunity to approach them himself and perhaps offer to help out?
No, the MP doesn't need to approach them himself. They will have to say that, well, I think that we want to use you as a prosecution witness to show clearly, demonstrate to your court that, well, these people knew that the acts they were involved in was criminal in nature, and that's why they paid the MP. So the evidence of the MP will simply be that, well, I was paid to kill the story in the media. and because it was damning and indictful of the accused person. That will be his evidence, and that's what the prosecution is.
Well, I know I've held you on the line for some time. Usually when I have you on the line, I just keep going. But perhaps I will conclude on this note. Yeah. Because on the note of the presidency released a press statement. There's a statement out in the public. It's a short one. And it reads, President Mahama has received 3 petitions from various persons seeking the removal of the Chief Justice. The President has forwarded the 3 petitions to the Council of State to commence the consultation process mandated by Article 146 of the 1992 Constitution. Is that to say a process has been triggered that could lead potentially to the removal of the CJ?
The process has been triggered in line with the Constitution. I mean, when the President receives a petition for to remove a Chief Justice, the petition would be the petition will have to transfer to the Council of State for advice. And thereafter, if the Council of State advises that processes will put in place to ensure that the trigger to raise a prima facie case against the Chief Justice, then the President will then direct that the necessary procedures be taken to set up a tribunal to determine whether the Chief Justice should be removed or not. And the President has to act in accordance with the advice. If the Council of State says that they are not convinced that there are solid grounds for the removal of a Chief Justice, the President will act in accordance with that. It appears to me that in this particular case, the President is just invoking the constitutional processes laid down for the removal of a Chief Justice. And it is important for us to await what the Council of State will advise.
The last time it was an EC chairperson which this process was triggered against and was successful under Nanado, which led to the removal of Charlotte Osei from office and Jean Mensah being put in office. This is the CJ, the Chief Justice, the leader of the judiciary. Now, I realized also that going back into history, people will tell you that we actually did petition for the removal of CJs in the past. But the presidents at the time did not act on those petitions. Are there serious repercussions to going ahead with this and succeeding?
Well, I'm a constitutionalist. I'm a constitutionalist. And I have always said that it appears to me that the President, when he receives a petition, should not make a decision on that petition. Should forward it, and the Council of State will make a decision.
Okay.
And then advise the President. That's what the Constitution seems to say.
You're saying the President has no discretionary rule when it comes to...
in that, yes, you receive, and then... So, you recall that when one of the last acts of Nana Akufo-Addo was to say that they received a petition and that he thought that the petition lacked merit.